This is a trademark and this is a patent. I have both. But I'm not a patent attorney. I'm a business owner that sells products. So today I'd like to give you my perspective as a business owner. We're going to talk about the differences between patents and trademarks, how to get them, how much they cost, why they're so valuable, and what to do once you actually have them. Because there are steps you must take. Because what we're talking about is intellectual property, protecting your ideas. My name's Evan. I'm the CEO and founder of Scorch Marker, an American-made craft supply company. We invented the Scorch Marker and Maker's Magic. We've done well over $6 million in sales on Amazon and our website. And over the last couple of years, we've gotten into retailers like Michael's, Walmart, and Hobby Lobby. So I've learned a lot throughout the process, and I really want to give you my perspective as a person that sells products that's been doing this for 7, 8 years. What's it like as a business owner to deal with trademarks and patents? But before we get started, let me tell you a quick story about something that happened to me that really opened up my eyes to how all of these things work. So in 2018, when I launched Scorch Marker, I remember the first ever formula we created. We had drawn it onto the wood, we heated it up, it burned in, it was incredible. And after a few months went by, I went to my wife and I said, hey, let me take $500 out of our savings. I have a feeling that somebody might buy this product if we put our formula into a marker. She gave me the okay, so I did. I went on Amazon and I bought every single empty marker I could find. I wanted to test them all out. I ended up finding one, and that's what I was looking for on Alibaba. So I found a manufacturer that did paint markers. And I said, hey, can I buy some empty ones from you? All I want you to do is put my label on it. That's it. Just send them to me empty. And they said, sure, no problem. They were more than happy. So I did that very thing. I designed a label. I sent it over to them. They made me a proof. They sent me some samples, and they sent me a bunch of empty markers. Well, once they saw that I was ordering, 30,000 empty markers at a time, they were really curious as to what I was doing with them and what I was selling. And it was in that moment that they decided to copy me and knock me off. So they didn't have the formula in the marker. That's been secret. Like Coca-Cola, me and one other person on the planet knows what's in our Scorch markers and our Scorch paint. All of our products, for that matter. So they created their own version of the Scorch marker and copied our name, copied our branding, copied our reviews, copied our infographics. They copied everything. And then they split up a bunch of different brands and started selling the exact same product under a bunch of different names. That was my first run-in with intellectual property, and it happened about a year after we launched on Amazon. So, naturally, I went to go get a trademark on our product and file a patent so I could have something to protect. And what I quickly realized in that process is that this Chinese manufacturer had already beat me to the punch. They had filed a trademark for my company, for my name, on their behalf for their company in China. They were working with a law firm down in San Diego, and the paperwork had already been submitted. And I was like, how did they prove that they're using this in commerce? Well, they had taken photos of the shipments they sent to me, and they had erased the label and used Photoshop to put their own label on it, showing that they were using it in commerce and they were ordering. Oh, it was a headache, and I had no idea what to do. So I got a reference from my aunt who works in retail and knows a bunch of attorneys and whatnot. And I, reached out to probably the most expensive attorney in Southern California, $800 an hour. Now, she was very kind. Teresa, shout out to you. She was very patient with me and very kind to me. She respected the fact that I was a fireman. She gave me a good deal. But what she had to do is she had to go to this law firm and explain to what happened, and then she had to help me figure out how to submit the documents properly so we could kind of circumvent this process. Without her help, I would have been dead in the water. So I'm very lucky to have had her. And that was my literal very first experience with any type of intellectual property and or trademarks. Eventually, we were able to get the word Scorch Marker trademarked on the supplemental register. I'll explain what that means in a few moments, so we'll come back to it. So I got my very first trademark on the supplemental register, and that was a big step. We were able to stop the Chinese company from infringing and filing in the United States, and I was able to proceed. But I was now keenly aware that, oh my gosh, I need to protect this, right? I need to do something. So then I started doing research on how to fill out my own patent. Now, before we get into patents and trademarks and stuff, let me explain the basis of what these things mean. We have utility patents, design patents, and plant patents. Utility patents are the way something works. Design patents are the way that something looks, and seed patents are for new types of plants that you've invented by crossbreeding. In our case, we're going to focus on utility and design patents. Now, for me, with the scorch marker, we needed to focus on the way that it worked, the application method, how it actually reacted with the wood and the chemical composition. And so I'm like, okay, cool. I'm a smart guy. Like, I'm pretty sure I could figure this out. So I started doing research and learning what it took to file a patent. I didn't have a lot of money at the time, like almost none. I was making $24 an hour at the fire department. So I didn't have a bunch of money to spend, and I knew that patents were expensive. So I had applied for some grants. I had applied for some patent and trademark training programs, and none of that went anywhere. So I'm like, okay, maybe I got to do this myself. So I started doing some research and learning and figuring out that like you can do it yourself, but there's a lot of training that you have to go through, and it is a very arduous, like nitpicky, detailed process. And very soon I realized that this wasn't the type of work that either I was cut out for or had the time and energy to learn and dive into. So I resigned and I'm like, okay, I need to work with a patent agent or patent attorney. And that's when I started to learn the differences of the two. Attorneys are lawyers, plain and simple. And a patent agent is someone who's been through that training that I talked about, and they are qualified to write and put together and submit patents on your behalf. So I found a patent agent out of Colorado. We started talking. I sent him some product. We went through it and we wrote a patent. And this is what you can see here. Now, during this process, I learned a lot. For example, I learned that the first time you make your invention or your product public, it starts a timer. And that timer means that you have 1 year to file for a patent before you are ineligible. You can't file for a patent if it's been public knowledge for over a year. So I was like, okay, good. I'm glad we're doing this now because I just started. All right, safe. So what that means is that I needed to at least submit something, at least tell the USPTO that I was intending to submit a patent. Because I'm like, I don't know if I can finish this whole thing before that timer's up. That's where provisional patents come in. So you're going to hear these words provisional and non-provisional. Provisional means that it's good for a year. It buys you another year of time. Non-provisional means that it's a full patent and it lasts 15 or 20 years or so. So I went to this patent agent and I'm like, let's get a provisional patent in immediately. And then let's work to turn that into a non-provisional. Okay. So let's get the temporary patent. Let's just get it going so we can file and make sure they have notice. And then in that time frame, let's work on the larger patent. So that's what we did. And what we decided to do was go after the methodology, how this thing works. So we laid everything out. We took photos of the markers. We wrote a whole thing and eventually submitted it. And I was granted a provisional patent first. And then after we submitted the non-provisional application, we were granted a non-provisional utility patent on our scorch marker. Okay, so now I've got a trademark on the supplemental register. Remember, we're going to revisit that. And then I've got a utility patent, both provisional and non-provisional, on my marker itself. How it works, the chemistry behind it, how it's dispensed, etc. So I'm like, okay, great. Like, I'm protected. No, I'm not protected. Now I just have something that I own intellectual property-wise that I can enforce. You see, patents don't protect you. They don't stop other people from copying you or knocking you off. They just give you the opportunity for legal recourse. They give you the ability to sue someone. They give you the chance to defend yourself. So patents and trademarks aren't the end-all be-all. They just give you legal ground to stand on. And what I have come to realize is that this legal ground, it's not black and white. It's all gray. And it only becomes black and white in court when a judge slams the gavel and rules in someone's favor. Guess what? Going to court is expensive, really expensive, hundreds of thousands of dollars expensive, and not something that I have the money for. I'll tell you a story about that in a moment. But before I do, let's rewind a second and talk about the differences between the registers, supplemental and principal. So there are two places that your trademarks can be registered. Now, a trademark is a word or phrase or a name. You're protecting words themselves. It was very difficult for me to get scorch marker trademarked because they're two very common words, scorch and marker. And USPTO was like, dude, you can't stop people from saying those words together. Like, that's not your unique thing. Those are common English words. So the best we're going to give you is a spot on the supplemental register. Now, if you use this in commerce and you make it a big name and you use your industriousness and social media and you get it out there and you keep using it in commerce and it becomes its own thing, then like yeah, sure, we can bump you up to the principal register, but you need to prove yourself first, right? So the supplemental register is for words and phrases that are kind of like, that's iffy, but if you make it mean something, then you might be able to trademark it. Now, trademarks are a slam dunk if they're random words like Facebook or Google or Pinterest. Those are all very easy to trademark because they're not common English words. So those trademarks went on the principal register right away. But because I was trying to trademark scorch marker, it was fairly difficult. So I had to start out on the supplemental register. But here's what we did. We kept going. We didn't quit. We leveraged that trademark in a couple different ways, which I will talk about. And eventually, we went back to the USPTO and filed that word mark or that trademark to be on the principal register, and it was granted because we had continued building the business and using it in commerce. We made it mean something. It's a very important takeaway. So that's what patents and trademarks are. It's a way for you to protect yourself. But why are they valuable to me, and why would I even go after them in the first place? Right? Why spend the money? Why waste my time? Well, there's a couple reasons. The first is it gives you legal grounds to protect yourself in case anyone is trying to rip you off, specifically Chinese suppliers in my case, or other competitors. The next thing is that it gives you clout. It gives you clout when working with retailers. It gives you clout when working with other industry professionals. It gives you clout on Amazon specifically when it comes to brand registry. So what do I mean by clout? If you have the ability to get yourself a patent or a trademark, a design patent, any type of word mark or intellectual property, it means you've created something unique that the USPTO was like, all right, cool. Yeah, you're good. That's unique. You did something cool. And so, first of all, they know that you've created something unique that you own. Second of all, it's an expensive and difficult process. So they know that you've done hard things and that you're willing to jump through hoops in order to get what you want. And last of all, they are leverageable. So think about it in terms of like both social capital and capital for your business because they're both applicable, right? But when you tell someone like, yep, it's patented, we can protect it, I've got the trademarks, they're like, oh, okay, this guy means business. And that's exactly what happened to me. However, the most beneficial thing that I've experienced is having a trademark. Out of all the things that I have, the trademark has been the most valuable. Why? Because of Amazon brand registry. When you set up an Amazon Seller Center account, you have an option to submit your intellectual property. In this case, it can be a patent or it can be a trademark or a copyright. But in my personal opinion, trademarks are the most powerful. All you have to do is upload your certificate to Amazon. And then they'll look at you and be like, oh, okay, this guy's legit. He's for real. We're going to give you more space on your product listing page to tell us about your business, your product, and represent your intellectual property. We will take down other brands that are infringing on your mark. And if you do it long enough, we will give you access to enhanced brand content. So there's some definite leverage points that you can get from Amazon just from having a trademark. And so that's where we started. I uploaded my trademark. We got access to A+ content. After a little while, more reviews, more selling, we got access to enhanced brand content. And all of this allowed us to put more content on our product pages, our display pages. It allowed us to get more sales, have better conversion rates, and get our messaging across even better. You can see the difference on those Amazon listings if you go through and you look. Some of them have like no content on them. Some of them have extra content, and then some of them have like tables and links to their store pages and all kinds of stuff. That's what trademarks allow you to do. Now, you might be saying, well, if I have a patent, do I really need a trademark? Or if I trademark, do I really have a patent? Yes and no. It really depends on how you want to go about it. Some people like that have supplements or dog treats, maybe patents aren't the best bet for them. But a trademark, that's almost always worth it, no matter your business, no matter your industry, because it gives you some legal ground to stand on and it will enhance your business. So patents are for everybody. They're expensive, and all they do is allow you to defend yourself, right? They don't protect you from anything. Now, trademarks, however, are much easier to get. They're much more affordable. They take way less time, and they can give you even more legal recourse. Let me give you an example. I recently sued 180 Amazon infringers. 180. There was 180 individual sellers that were infringing on our trademarks and our patents. And so when I was speaking to the attorney about this, I was like, well, wouldn't our patent be helpful to, sue them and recover damages? And they said, no, actually, Patents are so hard to prove out and it takes so much time in court that it's almost not worth it. Plus, you can't really recover damages on a utility patent like you can on a trademark. I was like, really? Like it's easier to get damages on a trademark? They said, yeah, it is because it's more black and white. It's easier to say yes or no, and it's easier to understand, and it's more clear. So, in fact, Evan, damages are more likely to be recouped. That means money you get back from suing somebody. You can get damages beyond the infringement. You can get much greater damages from a trademark than you can from a patent. So we're going to go after them based on your trademarks. And I was like, whoa, okay, that's really interesting. So it took us about 6 months to build the case and put everything together, but eventually we did submit it through an attorney on a contingency, and they felt that we had a great case to not only remove all the infringers from Amazon, but to recoup damages. So I bring this up for a couple of reasons. The first is that trademarks can actually be more valuable. Secondly, trademarks are easier, faster, and more affordable to get. Third, it's hard to prove and defend patents. It takes money. It's a great thing to have, and I definitely recommend going through the process if that's something that is important to you, but I would start with a trademark. But before we go further, I need to tell you a run-in that I had with a big company, right? So this product right here, Maker's Magic, this is an all-purpose craft glue and sealer. It's a Mod Podge competitor. Now, in the beginning, I had asked my customers, I said, hey, what is it that you don't like about Mod Podge, right? Tell me what you would change if you could change anything at all. And they gave me this long list. And I'm like, okay, I can fix that. So we did with this product. So when it came to naming the product, I'm like, oh, Magic Modge. That's it, right? Mod Podge is Mod Podge, right? I looked up the trademarks. They don't have a trademark for Mod Podge, right? It's Mod Podge. There's no Modge in any of their trademarks, any of their intellectual property, anything that they own. It's just like a common misspeak that people make. You'll hear people call it Mod Podge all the time when it's actually Mod Podge, right? So I'm like, this is perfect. This is our competitor. We're going to David and Goliath them. We're going to call it Magic Modge. So I started making content. I started testing and doing video replies and having our customers sign up on an email list so that we could notify them when we went live. And so I'm building up this email list and I've got a few thousand people on it and I'm making videos and we send everything into Amazon and it's live. So I email everybody on the list and I'm like, here's a coupon. We're live on Amazon. It's the only place you can get it. We're going to run out. We only have 200 and we sold out in a couple hours. Boom, 200 units gone. That got us #1 new release and kickstarted our buyer seller ranking on Amazon. And because of the outside traffic that we sent in, Amazon was like, dude, this is a real thing. Let's show this to more people. We don't need to suppress this listing, which is something that they do for new products. So we were off to the races. We were running and gunning. We were getting shit done. And then I got a message from Plaid, the company that owns Mod Podge. And they sent me a strongly worded cease and desist letter. They said, you can't name your product Magic Modge because it's too similar to our product. Customers might get confused. And so I went back to Amazon and I'm like, hey, look, here's their trademarks. Here's what we're making. This has nothing to do with them. They don't have the trademark on this. Like, this is us. We own it. And Amazon was like, okay, cool. And then 24 hours later, listing deactivated. Plaid had gone to Amazon directly and they're like, dude, these guys are in violation. And Amazon just went and removed our listing. And so it was at that moment I was like, what the hell? Can they do that? So I reached out to my attorney and I said, hey, I thought I was okay here. And that's when the attorney schooled me, for lack of a better term. He was like, dude, it's not black and white. And the only way it becomes black and white is in court. And to go to court with them is going to cost you over $300,000. So you have two options. And you might win. You might very well win. But then what? You have the name, you're $300,000 poorer, and you've lost all this time. So he encouraged me to change the name. And I was like, you know what? You're right. I did some research and I talked to some colleagues, and that company has a history of burying small businesses like mine. So at the time, I wasn't well enough equipped. I didn't have the resources to go to battle. So I very respectfully said, you got it. Okay, no problem. We'll take care of it. We will change everything. So for the remaining units that said Magic Modge, I put a question mark sticker over it, and we made a game out of it to rename the product. I ran a contest with our followers, with our people. I got all these suggestions, and out of all of them, Maker's Magic stood out, and that's what we chose. So I learned a very valuable lesson in that process. And that lesson was that everything is gray until proven black and white in court, and court costs money. And if you don't have the money, you need to play it safe and be careful whose feathers you ruffle. Now, as eye-opening as that experience was, I'm very grateful for it, because in the grand scheme of things, it was $20,000 worth of stuff, you know what I mean? Not that big of a deal. So we changed the name, we changed the labels, we changed the branding, and we got everything squared away. And it was after that experience that I was like, okay, intellectual property is important. I need to get trademarks on all of this stuff. I need to make sure that we're protected. I need to make sure that Amazon knows that we have these marks, and I just need to start collecting them. I need Amazon to know that we own this stuff, and I need to own it before a competitor owns it after they've seen our success. So now I get trademarks for any of our proven products. If they're worth anything, if the test has gone well, if people are buying them, I get a trademark. And that's a great segue into how we get trademarks and patents and how much they cost. So let's talk about that. The first thing I want to mention is that all attorneys are not created equal. There are attorneys that specialize in divorce law, constitutional law, medical claims, Medicare, insurance, corporate. They all have their different specialties. They can't all know everything about everything. So the people that you want to find and work with are two different types of people. You have patent attorneys and you have trademark attorneys. Those are the big two. So that's who you need to find. Patent attorney and trademark attorney. They're both very different. The patent attorney is going to help you write, submit, and validate the way something works or the way something looks to submit for a patent with the USPTO. Trademark attorney is going to help you get the word mark for your business, whether it's on the supplemental or the principal register. They both are going to talk to the US Patent and Trademark Office, but they both specialize in different things. In my personal opinion, I would start with the trademark. Trademarks are going to cost you between $1,000 and $2,000 to work with a patent attorney to get it all done. They're not terribly expensive compared to something like a utility patent, which takes a lot more work and a lot more time. Utility patent's probably going to cost upwards of $10,000 to do it right and to go through all the processes and make sure all the prior research is done and the searches and whatnot. Searches? What do you mean by that, Evan? Well, whenever you go to apply for a trademark or a patent, you have to do a search, and you've got to make sure that there aren't already existing patents or trademarks that you would be infringing on by applying for it. The USPTO is going to do it, plus they want to see that you've searched as well. So oftentimes these patent attorneys and trademark attorneys will hire a third-party company to do a trademark or a patent search. These people will look at your technology, what you're trying to patent, and then they will go search all the databases and pull up anything that's remotely similar. And this will give you an idea on whether or not you're able to get things patented. For example, you might see that, oh shoot, they already have a design patent on that, or they already have a utility patent for something very, very similar. This isn't going to work. We have to go a different direction. Or you might find that there's a trademark that you missed that's so similar that it's not going to work. So we do these searches beforehand, and that's something that's typically included in the process. But if that search comes back negative and you're good to go, these attorneys will collect your information. They'll learn about the product when you first introduce it to the public, what you want protected, and they will get it pushed through for you. I have a trademark attorney that I work with who is great. I also have a patent attorney that I work with that is great. They both cost different amounts, and they both specialize in different things. So when you are building this business, my best advice for you is to start with the trademarks. They're much easier to get, they're much faster, and they're much more affordable. And they give you more recourse, they give you more power, they're more leverageable, they're easier to defend, and they can make you more money than a utility patent. Once the business is up and running and you're selling product and you're making money and it's successful, you have product market fit and you're turning a profit, you can then take some of that money and invest it into a utility patent to better protect yourself and have more intellectual property available to you. It'll make your business more valuable, and it will make it more valuable to a buyer or an investor, and it will also give you more legal standing in case somebody decides to infringe on you using your exact same technology. And for me, that was important because we invented a brand new thing. There weren't wood burning markers before us. There was no such thing as a scorch marker. We invented a category. Now I own the patents and the trademarks for all this stuff. And as these Chinese sellers have, continued to saturate the market and steal market share from us, I can now put together this case with the law firm, and I can say, dude, these guys are costing us business. Look at how much we've sold. Look at how many markers have gone through our doors and into our customers' hands. Look at all of our reviews and all of our social media. These people are literally copying us, and it could be confused with the real true product, the owners of the trademarks. So instead of suing the individuals, this law firm sues Amazon. They sue Walmart.com. They sue eBay. And Amazon doesn't give a shit about its sellers. If you sell there, you know that to be true. They're just going to shut them down and be like, okay, we'd rather just not deal with a lawsuit. We're just going to shut them down, close their accounts, freeze their funds, and then just give you the money that was in their accounts as the damages. And then we're good as a third party marketplace. It's a really interesting world that we're living in right now with intellectual property and all these third party marketplaces. A third party marketplace is like Amazon, eBay, Etsy, Walmart.com, etc. They're the facilitators of the transactions. So now that you understand how these things work, what I've been through, how much they cost, how to get them, and the differences between them and why they're so valuable to me, let's talk about what you need to do once you have them. I recommend printing them out or paying the USPTO $25 to give you a certified copy of the certificate. Put them on your freaking wall, man. It's something to be proud of. It's something you've invested in. It's something you want on display. And, that's for your own personal reasons. I just think it feels good to have these kinds of things on your wall. But you also have to do a few things to your product. We've all seen the R symbol with the circle around it. That means all rights reserved. That means you own the rights to that mark. You'll also see like a TM or a copyright. But here's what you need to do when you get a trademark. Now that Maker's Magic is trademarked, I need to put a little R with a symbol next to the word to prove that it is trademarked. If I don't, I'm going to have a really hard time defending it. When you have a patent, you need to put your patent number on your product. You need to put it on the packaging, put it on the product itself. Because if other people don't know that it's patented, they could claim like, hey, they didn't notify us that it was patented or trademarked. Like, how were we supposed to know? And you're going to have less legal ground to stand on if you ever run into an issue. So as soon as you get these trademarks, you need to update your labels, you need to update your website, you need to update your Amazon listing. You need to submit the trademarks to these platforms so they know that you're the intellectual property holder. And then you need to notify everybody, including your customers, with those little symbols. Then you don't have to go shout it from the rooftops or send out email blasts or make social media posts about it. But you do need to change your logos and you do need to update them to make it clear. This is going to protect you. This is going to give you more legal recourse, because if you don't tell people your stuff is patented and trademarked, you won't have that ground and a law firm won't take you on. They won't do the work. Now, in our case, we did that. We proved all this stuff out. And this law firm was like, holy cow, there's a lot of people that have infringed on your mark. Like, I can't believe this is happening. You know what? We're going to take you on and not charge you any money. If we recoup damages, we want half. Okay, sounds great. And that's the position that I was in. Because I had done such a poor job of enforcing it, we had all these infringers that have kind of built up. So if I could go back in time, I would have done a couple things differently. I would have applied for a trademark for every single one of our products. I also would have put the little symbol as soon as I got everything on all of our products and all of our product names. As soon as I got the patent, I would put the patent information, just everywhere. And then as these infringers started popping up on Amazon, I would work with a law firm, a secondary law firm, one I haven't told you about yet, that scans all these websites and tells you when someone's infringing. Now, I made a mistake. We had the trademark for Scorch Marker, but all of the knockoffs were putting Scorch Pen Marker. And I'm like, oh, they put one word in between. Like, shoot, nothing I can do. I was so wrong. There's a lot you can do. Because the average person might confuse them with you. And that's enough legal recourse to do something about it. I just didn't know that. I didn't know I could do anything. I thought that I was, up Street Creek without a paddle because they put words in between and it wasn't technically an infringement. Yes, it is technically an infringement. And we needed to prove that. We needed to put together a case and show them what we had. And we could have totally gotten these people taken down. But I didn't know. Luckily, we're able to deal with it now. But if I could go back in time, I would have done way more enforcement and I would have better understood what ground I had to stand on and what I had to protect. So before we end this, I want to cover the secondary law firm that scrapes the data and helps you enforce. I was working with a lady named Cheryl, and her company uses AI to scrape third-party marketplaces and the internet. You basically upload your trademarks and your patents and your word marks and your logos and your pictures, and they will look at all these different places and they'll come up with a list of all the people that are infringing. You can also tell them who you're selling to and who has permission and whatnot. But basically you go down the list and you just check the boxes and then you hit remove, and they will send cease and desist letters to the platforms instead of the sellers, and the platforms will remove these people. It's actually a really affordable service. It's like $200 a month. So if you'd like to be connected, reach out to me on Instagram with a DM and I'll send you their email. Great people. That was the law firm that connected me with the other law firm that is suing these platforms for me. So we're all going to split up the money if we get any damages back. And that has been my experience with patents and trademarks. It's been like this. I've been punched in the gut, punched in the face, kicked in the nuts so many times. And to be standing here still thriving and still in business, knowing that I have a little bit of legal recourse and I might be able to claw back some ground, feels really good. So it was an ample time and a great opportunity for me to be able to tell you what I have learned over the last 8 years of going through it and what I'm doing about it and what I've learned. Because when we go look this stuff up, we're hearing stuff from attorneys and patent agents and legal people, and they don't speak like we speak. They don't talk like we talk. They're not doing what we're doing. They're not operating a business and selling a product. They don't know what it feels like to have your hard work capitalized on by a knockoff. It sucks, dude. It feels horrible. Not fun. And that's why I wanted to make this video. I wanted you to hear my perspective on it. Because I sell on our website, I sell into Amazon, we're in Hobby Lobby, we're in Michael's, we're in Walmart, we have a relationship with other retailers, like we're growing. And I think it's important we talk amongst ourselves and we figure this out together. Sometimes when another business owner puts it in a way that we can understand, it just clicks. And I'm hoping that I did that for you here today. Now, if you're looking for that group of people, that circle, those entrepreneurs, to be around more people like me, like I've actually built a community for us. I host it on Circle where I take all my knowledge, everything that I've learned and I'm still learning, and I put it into courses, and I have forums and I host discussions. But most importantly, every Thursday we get together on a Zoom call. We talk about this stuff. Hey, Evan, I'm thinking about getting a trademark for this versus a patent. And we've gone through these talks multiple times. We talk about content. We talk about your business plan. We talk about your margin and your pricing strategies and advertising strategies and all the different things that we need to be good at as business owners, because we are the person that's going to get us to 7 figures. You can do it. Owner operator, small lean team, you and 1 or 2 other people. But beyond 7 figures, to get to 8 figures a year in sales, you need to become a new person. You need to have the fundamentals mastered. And we really focus on those fundamentals. So if you're interested or you want to try it out for $1, just meet with me, see what it's all about. You can go to Vanader.com. I'll also leave links in the description for you. Otherwise, I want to wrap up this video by talking about our actual sales figures. And that's what we're going to do next. So let's go over how much money we made on Shopify, on Amazon, and from retailers, so you can get an idea of where I'm at in business and whether or not you should even listen to anything that I have to say. The following sales figures are from the 4 weeks between January 6th and February 2nd. On Shopify, we did a total of $11,152.24, and that's at a conversion rate of 1.54%. On Amazon, we did a total of $35,742.32. That's at a conversion rate of 11.57%. And for retail, we were paid out over $15,202.48. Conversion rate is not applicable. This brings our grand total for the 4-week period to $62,097.42. To earn that in sales, we spent just under $10,000 in ad spend across Meta and Amazon. Now remember, these figures are in January to February. We're coming off our busiest season, which is Q4. We're slowly turning down our ad spend, getting prepped for our final sale in March, and then we go into our off season. We begin scaling up again in September. So lower figures during this time of year are quite common for businesses in our space. Not everyone experiences this type of seasonality. We're all a little bit different, but I wanted to give you some insight into how our business looks as we're coming off Q4. I'll see you in the next video.